I am Dr. M. Prakash, Associate Professor, Department of Commerce, PA and IT, Kamadin Arts and Science College, Satyamangalam. In this video, we are going to discuss about the business law subject in Sale of Goods Act 1930. The Sale of Goods Act, we discuss the following topics. First of all, introduction, then essentials of conduct of sale, including the types of goods also. Then differences between sale and agreement to sell. The history of Sale of Goods Act. Sale of Goods Act was enacted in 1930 and it is borrowed from the English Sale of Goods Act 1893. It came into force in July 1, 1930. Prior to the Act, the law of sale of goods was contained in Chapter 7 of the Indian Contract Act 1872. It extends to whole India except Jammu and Kashmir. The definition about the Sale of Goods Act. Section 4, subsection 1 of the Sale of Goods Act 1930 defines the conduct of sale of goods in the following manner. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. So in the definition, we definitely noted the sale of goods is contained for three important words. One is the transfer of goods, another one is the goods, then price. The next, the essentials of contract of sale. From the above definition, the following essentials of a contract of sale may be required. First of all, there must be at least two parties, like that the buyer and seller. Then second essential is transfer or agreement to transfer the ownership of goods. And third, the subject matter of the contract must necessarily be goods. Particularly the sale of immovable property is not covered under this act. The fourth one, the consideration, because the consideration is the price. The fifth one, a contract of sale may be in writing or by words of mouth. And finally, all other essential elements of a valid contract must be present in contract of sale also. Then important one, the goods, because the goods is the major part of the contract of sale. The definition of goods under this act. First of all, we should note the meaning about the goods. Goods means every kind of movable property and includes stocks and shares, growing crops, grass, and things attached to or forming part of the land, which are agreed to be severed before sale or under the contract of sale. But the actionable claims and money are not included in the definition of goods. The goods include every kind of movable property other than actionable claim or money. For example, goodwill, copyright, trademark, patents, water, gas, and electricity also are all goods and may be the subject matter of contract of sale. The test is if the property on shifting its situation does not lose its character. The said property shall be movable and fall within the definition of goods. So the definition of goods, definitely we have noted the goods are all movable property only. The immovable property we should not take in the contract of sale. Then goods. And now we discuss about the types of goods. The goods are classified into three types. First one, existing goods. Goods which are physically in existence and which are in seller ownership and are possession at the time of entering the contract of sale are called existing goods. Where seller is the owner, he has the general property in them. For example, suppose you can sell your mobile phone on online definitely you put the advertisement and show the relevant information about the phone. Then only the buyer also like to buy your the cell phone. So that is called the existing goods. Then second one, future goods. Goods to be manufactured, produced or acquired by the seller after making the contract of the sale. It's called future goods. It clearly exists in section 2, subsection 6. These goods may be either not in existence or be in existence but not yet acquired by the seller. We also have one examples for future goods. Mr. A agrees to sell to B all the milk that his cow may yield during the coming year. This is a contract for the sale of future goods. Then third goods, the contingent goods. This is a type of future goods also, and those are the goods the acquisition of which by the seller depends upon a contingency, which may or may not happen. It clearly explained in section 6 and subsection 2. For example, A agrees to sell to B a specific rare painting as provided he is able to purchase it from its present owner. This is a contract for the sale of contingent goods because it may happen or may not happen. And another one example for the contingent goods, Mr. A agrees to sell to B 25 bales of Egyptian cotton provided the ship which is bringing them reaches the port safely. It is a contract for the sale of contingent goods because if the ship is sunk, the contract becomes void and definitely the seller is not liable. This is the example for contingent goods. And now we discuss the sale and agreement to sell. So it means the definition and the meaning and also the differences. First of all, we should know about the sale. Sale, it is a contract where the ownership in the goods is transferred by the seller to the buyer immediately at the conclusion contract. Thus, it is strictly speaking that the sale takes place when there is a transfer of property in goods from the seller to the buyer. A sale is an executed contract. It must be noted that the payment of price is immaterial to the transfer of property in goods. So, in the case of sale, the possession of the goods is immediately transferred from the seller to the buyer. We also have one example for sale. A sells his Yamaha motor bicycle to B for rupees 10,000. It is a sale since the ownership of the motorcycle has been transferred from A to B immediately. Next one, agreement to sell. It is a contract of sale where the transfer of property in goods is to take place at a future date or subject to some condition thereafter to be fulfilled. For example, Mr. A agreed to buy from B a certain quantity of nitrate of soda. The ship carrying the nitrate of soda was yet to arrive. This is an agreement to sell. In this case, the ownership of nitrate of soda is to be transferred to A on the arrival of the ship only. Because the containing the specific goods, like that the nitrate soda. So this is the agreement to sell. In agreement to sell, the transfer of property in goods is to take place and it's contain a future date and come some days. And now the differences between the sale and agreement to sell. It's simply called the sale. The ownership passes to the buyer. In agreement to sell, ownership remains within the seller. If sale is an executed contract, agreement to sell is an executory contract. The risk of loss falls on the buyer only. But in the case of agreement to sell, risk of loss falls on the seller. Then seller cannot resell the goods. But in the case of agreement to sell, seller also can sell the goods to the third party. And another one difference is sale it can be in case of existing and specific goods only. But in case of agreement to sell, it can be in case of future and unascertained goods also. In case of breach of a contract, the seller can sue for the price of the goods. In agreement to sell, suppose the breach of a contract, seller can sue only for damages but not for the price. The last difference is, in sale, the seller is only received to the ratable dividend of the price due if the buyer becomes insolvent. But in the case of agreement to sell, if the buyer becomes insolvent, the seller may refuse to sell the goods to the buyer. These are the differences between sale and agreement to sell. Thank you.